Welcome back to our session. Panel number 2 is going to start in a few minutes. One thing that's really special, this turned out to be a really amazing element of our Center for Intellectual Property and Entrepreneurship, is our clinic in entrepreneurship law. And I just wanted to briefly introduce our clinic director, Professor Jim Niemann, who's now finishing. I think he's now been here almost 2 years, but has really done tremendous things, both for the law school and in the community, and reaching out to local startups in the mid-Missouri and even broader area. And one great thing that Professor Niemann has done is brought in Professor Tom Laffey, who has been a legal and business executive at kind of the highest levels for many years, and so is bringing his experience to the law school as well, and to our students. And it's just turned out, before we started this clinic, I was really skeptical for a number of reasons about, are we going to be able to find clients, and will we really be able to provide them with legal services that really help them? And the response has just been so overwhelming, in that our clinic is turning away lots of clients because we're completely full, and the folks who come to this clinic, when they go away, they are really amazed at the level of both professionalism and the actual service that's happening in helping these small and growing companies kind of get off the ground. And so I just want to say thank you, Jim and Tom, for being a big part of this. So our second panel here, I'm very excited about, and you see standing behind me, raring to go, as he always comes with this real excitement about the law and thinking about it and explaining it and moving it in a positive direction, is Professor Peter Menell, and Peter is a very highly regarded law professor, both in the field of intellectual property and privacy and computer and software and trade secret law, but then generally amongst law professors across the world, in fact, is well known. He is amazing. He has this amazing ability to relationships with judges in particular, to help judges understand these very potentially complex areas of law and business. And so Peter has run a series of workshops on patent law and other doctrines to really get judges up to speed. And it may well happen that this same process needs to happen with trade secret law as well, because for the most part our federal judges haven't been dealing in this area. Now they're getting into it, and so I really commend Peter for this. Now, before Professor Peter Menell goes, I'll also introduce our second presenter, Yvette Liebesman, and Yvette is a wonderful addition to our Missouri legal ecosphere, and in fact, and I say that because she's in Missouri, and that she's a law professor at St. Louis University, and has been a leader in that university for many years, and has been known across the country for her work in intellectual property, especially trademark and copyright law, and thinking about some of these issues I was raising in my initial talk about about what are some concerns about how far these intellectual property rights reach and where should they cut off to allow for freedom of expression and free communication. And so I'm really glad that Professor Liebesman agreed to come. Now, our third speaker you cannot see, but she is kind of listening from above, and it's not our CIA director. It is, right, in fact, it's Robin Effron, who's a professor at Brooklyn Law School, and Robin will be speaking via electronic, I believe it's Skype, but Robin's face and perhaps slides will be showing here on this screen as our third speaker. Robin has written substantially on trade secret law, but she's also been deeply involved with international law issues. And so some of the things that Professor Halligan was talking about in terms of the international components of these trade secret issues, she's been thinking and writing about, and that will be a substantial aspect of where she's headed with her talk. And I think the plan here is that we'll do a little like we did in our first panel, where we'll have the speakers present, and then at that point we'll take questions. Of course, at any point, if you feel the need to make a counter argument or raise a question or something's confusing, I'm confident our speakers will be really happy to and accept that if you want to break in. So Peter Menell.
Thank you, Dennis. Well, it's a real pleasure and honor to be here, and Dennis is too kind in his introduction, but I will say that I owe it to Dennis that my reputation has flourished, because his blog, Patently O, is what we all, and so many practitioners, judges, lawyers, all look to follow these areas. For me, my background did not develop, as Mark said, as a trade secret specialist. I've long taught intellectual property law. I've had a case book in this field. So I've taught trade secret law, but I hadn't written any articles on it until what you're about to hear. And it grows out of really, I think, serendipity. I was trying to explain to my students how trade secret law seemed to differ from patent and copyright trademark law, and that led me to ask, why are there no in the Uniform Trade Secret Acts, in the in the restatement and other materials, why really aren't there defenses in the same way that we see them in the other areas? And that led me down a path that you'll soon hear about. So this isn't quite working the way I had hoped, so I'll just use, oh, that was scary. I'll just use these. So I want to begin with a story. You might recognize this man in the background, perhaps not though. His name is Jeffrey Wigand. He is perhaps the most famous whistleblower in modern history, certainly on the short list. And he was the subject of a 60-minute special that was turned into a very interesting movie called The Insider. But he was working at Brown & Williamson, a tobacco company. He thought that he was there to improve the safety of cigarettes, but he learned that he was involved with an effort to really weaponize cigarettes and make them even more addictive. And that led him to want to get that information out, and the lawyers for Brown & Williamson were successful, at least for a while, in using trade secret law to prevent this violation of his non-disclosure agreements. Vanity Fair did a great expose. In fact, one of my colleagues at the University of California is a man named Lowell Bergman, and he's featured in the movie The Insider. He's the Al Pacino character. And it's, I think, one of the most engaging movies out there, but it highlights a really serious problem that we have with trade secrets. Trade secrets are supposed to promote commercial advantage. I mean, that was really the basis for the whole system on which we've built trade secrets, and I would say for much of its history that has been the focus. But things have happened in the American economy and in the role of government that have really shifted, I think, the the thinking about trade secrets, companies came to see trade secrets as really more than just a way to protect those commercial advantage benefits, that they could be used to protect all information within the company, some of which might be justifiable, privacy and other issues, but companies, I think, came to see it in a much broader way. And if you go across the street from our law school to our business school, you'll, I think, hear about trade secrets in a much larger way, that, that the professors teaching about human resources really see this as an essential way of protecting the company against all kinds of threats, some of which I don't think they should be protected from. My concern in following this case and thinking about how trade secret law is used is, are we balancing the larger social issues in the trade secret environment? And as Mark explained, we now have some balance built into this federal statute that wasn't there before. So when I'm teaching intellectual property, I talk about this honeycomb of different regimes. There isn't one thing called intellectual property. It's actually a variety of different, importantly, different regimes, and they reflect many of the background principles that we cover in our first-year curriculum: property, contracts, and torts, but they have a somewhat different orientation. Patents protect functional inventions, technological innovations. Copyright protects expression. Trademarks protect consumers against confusion. It promotes market integrity. Trade secrets have a variety. It's a much, I would say, more of a Swiss Army knife. It can be used in a lot of different ways, although it has certain limitations. And when we look at how a lot of these doctrines are put together, they have a number of these balancing factors. In patent law, we have a variety of different safety valves. Copyright as well. Trademark, right of publicity. All of these areas of law have developed a balance system. Whereas trade secret law, at least when I think about the Jeffrey Wigand case, seems to lack, or has lacked, that important social dimension. So I went back and doing this research to the very early roots of trade secret, the period that Mark was talking about. And trade secrets evolved really at an important transition in capitalist systems. That in the early 17th, 18th century, you had a guild economy. It was a very sort of simple, smaller scale economy. You didn't have globalization. You didn't have engineering schools. You essentially learned crafts and trades through guilds. And in fact, the patent system reflected that. The term of patent law is based on apprenticeship periods. And so you didn't need protection for what we worry about today, because there was a very strong and powerful way of policing information that's passed along through this regime. I mean, you really couldn't function in that local community if your mentor felt that you had violated, his important protections. And so we developed a very good economy for this much more simple technologically era. And then we get the Industrial Revolution, and we now move to this large-scale sort of factory economy. Employees are now going to be mobile. Information is much harder to protect in this mobile, much less sort of social norm-oriented system. And trade secret law evolves in that context. And this is all happening in the 19th century. It's not happening as a matter of federal statutory law, as patents and copyrights had, but really through this state law, common law type regime. And we get to what is a fairly broad definition of trade secrets, going back and then later codified in the Uniform Trade Secrets Act. And as part of trade secret protection, as we heard in the first hour, one has to have reasonable precautions. And one of the most important precautions is that your employees and your contractors are not going to be spilling the beans. And so it just became a common feature of most employment environments that people would sign non-disclosure agreements. And they are, when used appropriately, an important part of developing technology, innovation, thrives, and many other business values can thrive in this environment. But there is another important change that happens at the turn of the 20th century. As we get into the 20th century, the government goes from a very small part of our economy to a very significant part of our economy. Secondly, we're seeing government regulation emerge, and I'll defend government regulation. I know it's not popular these days, but I will say that having workplace safety laws and environmental protections and such things are an important part of a balanced economy. But even if you don't believe that, it is our world today, that the government plays a very significant role in what we do. And it's important to recognize that trade secret law really developed before these kind of protections. And what we're doing through this whistleblower provision and certain other parts of trade secret law now is adapting the law to this world in which we live. Now, it's really interesting to look at government spending as a percentage of our economy. And again, one can criticize where we are, and that's a political issue. But to see that we spend nearly half of our domestic product through the government. We are not a purely private economy. We are very much a government-private economy balance, with nearly half of of total spending being either federal or state and local government. And so with so much money being allocated through this process, there's a great risk that we will waste those resources, that people can defraud the government, and that's in addition to our concerns about civil and other rights, human rights. These are things that are now a big part of our system. Now, another important part of our system is, going back to the Bill of Rights, our Fourth Amendment. And we say the right of people to be secure in their persons and houses. We can't allow searches and seizures without some adequate basis. So in order to enforce the law within our system, we have to have some sort of citizen reporting. It would be very difficult, especially in a highly trade secreted economy, to have law enforcement. And we talk about it a lot now in terms of threats of terrorist activity, but I think it's a much bigger concern, that we want to have a system where the rule of law works, and it works in the way that was intended, not merely as a gag order on people who are going to try to use privacy of information to enable illegal activities. So going back to the Civil War, turns out defrauding the government has been a popular activity for a very long time. President Lincoln recognized that the Union was not getting the products that they had contracted for, and we created the False Claims Act. We created a whistleblower system. It was referred to as Lincoln's Law, and was enforced going back all that period, but it got somewhat reduced in its effectiveness in the World War II period. And it was only after government spending skyrocketed in the 1980s that Congress revived or strengthened this law. And so we've had a fairly robust whistleblower system in place, where whistleblowers can get a percentage of the recovery by the government. And I would say it's been a fairly successful and popular law, at least among legislators. There's bipartisan support for this system. And when you look at what it's done for us as taxpayers, it's really, I think, a very exciting law. Over the last several years, you can see the government is receiving $4 or $5 billion as a result of this law. And it continues to grow. I think we're seeing a lot of bad activities being rooted out. And we're also, in addition to what gets recovered, we're deterring a lot of bad activities. And those are all things that we should be happy about. Here's an interesting little case study. So what's been happening in securities regulation? So this is an area that we also have concerns. It's a little different than the False Claims Act. And there was a whistleblower provision going back to Sarbanes-Oxley, but it was producing about 334 on average, in that range, tips to the SEC per year. And then in Dodd-Frank, we expanded the whistleblower provision. We made for better recovery for whistleblowers. And in that 1 year, we see a vast increase in the amount of these tips coming in. So an order of magnitude from 300 to 3,000 tips per year. Now the SEC doesn't pursue all of these, but what this has done is I think it's provided an important deterrent effect on the kinds of activities. If you watch, I think it's Showtime, the show Billions is one of our favorites now, but it highlights the problem. It's very difficult to root out those kinds of illegal activities unless employees or contractors are bringing forward that kind of information. So I spent the summer 2 years ago really trying to study the economics, the sociology, the psychology of whistleblowing. Professor Lobel, who will be talking later, has been one of the leaders in thinking about related issues. And it brought me into a whole body of research about what happens in companies. It turns out that there's this whole field of onboarding, and trade secrets are really quite involved with this. That when people are hired at major companies, they are going to be brought through an education process. And these sociologists who are working in HR have tried to sort of optimize techniques to create the most loyal employees imaginable. And so they've taken the work of Abraham Maslow and others, and they've tried to think, how can we really generate the perfect employee? And by perfect employee, we don't necessarily mean perfect in a social sense. What we mean are people who will be so loyal that if they become aware of illegal activity, they're not going to whistleblow because companies see that this is a risk to their bottom line. And I worry about this issue because when I think about companies, as we know from the Supreme Court, they are legal persons. But where do they get their morality from? That's the important question. We want to have corporate entities that are moral, socially moral. And the morality probably comes from a variety of sources: employees, managers, accountants, lawyers, shareholders, board of directors. But when I think about all of those folks, I'm worried. I don't think the shareholders are so concerned. The board of directors are really just trying to pump up the profits on an annual basis. The managers, employees actually can, I think, play an important and positive role, and that's what led me down this path. In many ways, the problem we're facing here, we heard about RICO earlier, which was an essential statute in bringing the mafia down. Well, in many ways, what a lot of the onboarding process is oriented is similar to the omerta. It's trying to build this sort of corporate loyalty that may go too far, and that's what I'm worried about. And when you sort of look into kind of the lore about whistleblowers, they're often, there are a lot of messaging within the corporate environment to discourage this activity. There's no shortage of political cartoons that captures this issue, and that's what I think is what I think a good company should care about whistleblowing, but not only to discourage it. They should want to encourage the companies to follow the law, and there are risks when people are raising these concerns, but the government isn't going to go after everyone to the maximum degree. The government is trying to achieve this balance as well, and thinking about how to do this is a challenge. So you might recall a few years ago we had Time magazine celebrating Sharon Watkins, who was the whistleblower at Enron, and other whistleblowers. But I think it's interesting to look behind the cover. Sharon Watkins becomes this kind of cover person, but when you look at the letter that she wrote, what became the essential document in the whole Enron crisis, it doesn't portray her in the nicest of light. Whistleblowers aren't perfect, but they are essential. So here she is writing to Ken Lay, the head of Enron. She says, "Has Enron become a risky place to work? For those of us who didn't get rich over the last few years, can we afford to stay?" She's essentially saying, hey, I see some problems out there, and I'm worried that I'm not going to be able to cash in like some of these other folks who are like Jeff Skilling. Skilling's abrupt departure will raise suspicions of accounting improprieties. Enron has been very aggressive in its accounting, most notably the Raptor transactions. The spotlight will be on us. The market just can't accept that Skilling is leaving his dream job. So here she is. She's basically saying, Skilling got his, I want mine. She's not saying, hey, we need to help the public. We need to avoid defrauding all our shareholders. So it goes on. I'm incredibly nervous that we will implode in a wave of accounting scandals. Right now she's reporting internally. She's not going public yet. My 8 years of Enron work history will be worth nothing on my resume. She doesn't sound like the nicest person, but is there a way our accounting gurus can unwind these deals? She's trying to get the company to at least face up to this issue. And ultimately, she does go public with these concerns, but it was only after she was trying to get her cash payment. But that's the reality. Whistleblowing is a very murky area, but had we not learned about the Enron scandal, we would be in far worse shape. And when you look at the events of 2008, you can see that the larger social effects of this information not getting out into the public are dramatic. That brings Bernie Madoff to the fore. So did anyone know about Madoff's illegal activity? Sure. Everyone working there was aware that this thing was not kosher. It was a pretty ugly situation. In fact, Harry Markopoulos, who was competing with Madoff and losing customers left and right, he said, there's no way you can have these consistent high returns. And he was trying to call attention to it, but no one would take up his case. The only profit he's earning is on book sales, because we didn't yet have a regime in place. So enabling this kind of whistleblowing is really important. I mean, just the Madoff scandal was $50 billion in lost money for shareholders. That's not a good situation. So we want to find some balance here. So I looked into the restatement that we heard about earlier. And what does it say about this kind of issue? Well, there is a comment which talks about public policy. It says the disclosure of another's trade secret for purposes other than commercial exploitation may implicate the interest in freedom of expression or advance another significant public interest. Okay, well, it sounds like they're doing the right thing, but then when you read further, the way in which this works is this multi-factor balancing test. It's a very murky test. And when you think about the economics of litigation, how many employees are in a position to go out and hire one of you to represent them in something that probably isn't ever going to return any money to them? So this is not a very good safe harbor. And we saw that in the case law. We saw that. This is one article that when I read it, I said, I can't believe a lawyer would write this. So here's someone promoting their legal practice, and they're saying, employers may even have options against employees who have been successful in their False Claims Act cases, but who have breached their employment agreements or have stolen documents. And they talk about, there's at least one case in which an employer filed suit against a whistleblower after losing a False Claims Act case. Now, this just doesn't seem to me like the kind of litigation that we want to be encouraging. But, I think if you're, looking to attract clients, this may be a way to do so. But it's not a, I think, good balance, and we see this in some of the cases. So in the Cafasso case, we have an engineer who's been working for years at General Dynamics, and she becomes aware that there may be some problems in the way they're handling issues. Interestingly, what she's concerned about is that the company might not be disclosing to the government patentable technologies. So it has another IP connection. And so the company brings a lawsuit against her because she's taking documents. And she's taking them for the purpose of preparing a False Claims Act complaint. And when she's doing it, she's not able to go through all the documents one by one and say, ooh, that's a good one, that's not a good one. She does what most people do, which is you put your memory stick into the computer and you say, move file. That's what you do. And that's what she did. And it turns out there were a lot of files there. And I can see why a company would be concerned about large files being removed. But it's being removed by an employee out of concern that the company is violating some laws. She gets fired. They get into a lawsuit. And the company is successful in bringing a lawsuit against her, even though none of this information leaked. It was all protected at all times. It was information the company didn't want known, probably because they didn't want the government investigating whether or not they had violated some government procurement or other rules. And so the standard is, was it reasonably necessary? Well, that's a case-by-case issue. That gets you into the murkiness of going through all these documents. I think the key issue here is whether or not the documents are being leaked outside of a confidential circle. And so that led me to think, is there a better way to solve this problem? For those of us who teach in the law school curriculum, there's a very famous article by Judge Calabresi and Douglas Melamed called Property Rules, Liability Rules, and Inalienability. And it provides a very nice framework for thinking about a lot of what we do in law school. And it divides the universe largely into property rules, things like what we teach in our property course, and IP law, and liability rules, where we allow more of a contractual remedy. We try to compensate you for harm. And it seemed to me that there's a nice sort of intermediate system that could help solve the problems that we're seeing in this trade secret area, whereby it's not protected, the information isn't protected by a property rule or a liability rule. It's protected so long as you maintain the secrecy with a trusted intermediary. The other thing that I thought was important is that the employees and contractors should know that they have this right to share that information in these trusted relationships. I took the idea mostly from Mel Brooks. If you remember the old Get Smart secret, the cone of silence never worked, but the concept of it is a really nice one, that you can have a completely private conversation, and it seemed to me this was a good idea. In fact, we use it all the time. It's routine in IP litigation. We create protective orders. We have different levels, who can see what. It's a really nice system that lawyers don't even argue about anymore. You start a case, you go to your protective order. We also have a rule that prohibits government employees from sharing confidential trade secret information. It's 18 U.S.C. section 1905. And this is what allows the FDA, the EPA, the PTO, and basically every government agency to do their job. And you could say, well, that's risky, you have all these employees. Well, there are relatively, I mean, it's hard to even think of major breaches of this rule. This rule seems to work pretty well. I mean, you might not trust the government, but this rule has enabled the FDA, the PTO, and many other agencies to function for a long time. The other interesting example I found was in HIPAA, the Health Insurance Portability and Accountability Act. In fact, built into HIPAA, where we have a lot of strong privacy rules, is a whistleblower protection rule. It says that if you're aware of fraud going on in these health businesses, that you are allowed, if you believe in good faith that they're engaged in unlawful contact, you're allowed to communicate that information to the health oversight agency and to an attorney. These groups are bound by the secrecies that we've talked about, and attorneys are bound by all kinds of rules barring disclosure of trade secrets. And so as Mark's bill was moving its way along, I wrote this article. I thought, let's get this idea out there. Maybe someone will pick it up. And I was quite happy when I got a call from the Senate Judiciary staff, and they said, we read your article and we want to do it. This was in November of 2015. I get this call and I'm like, okay, let's do it. And they pretty much did it. It's almost verbatim what I had used as my exam question the prior year in Introduction to IP. I had an immunity provision. I mean, it is very, very close. And it's had, I think, already a big effect. I mean, all law firms working in this area are informing their clients about these protections, the notice provision, et cetera. And I think that we're moving towards making trade secret a really balanced, thoughtful system that is protective of a lot of societal interests. So here's the language. It's pretty concise. It talks about protection or an immunity. I chose the word immunity. I didn't want to say defense. I said immunity because I think we want to avoid having to get to a defense stage. That if you require a whistleblower to have to defend the case, you've already discouraged them. If they call up an attorney and say, I have information that I think is quite problematic for our society, I would like to be able to get this to the government, and the lawyer says, well, are you subject to an NDA? They said, yes, I am. Then the lawyer would have to say, well, you could be sued for violating that NDA, and you would have to pay me to defend that. And I think the whistleblower would say, thank you very much, I'm done. I mean, that's not a situation that is going to produce the information that we need. I'd rather the lawyer say, well, listen, if you disclose it to me and we put it in a sealed document to the government, you are immune. And if someone sues you, we're going to file a motion to dismiss, and we'll be out of here. And that seemed to me the right balance. Now, there's a risk. I mean, you might find competitors. There's a big lawsuit right now between Google and Uber over the autonomous driving. Well, I don't think the whistleblower exception would work very well there. When you leave Google to go to Otto and then get sold to Uber to create exactly what you're doing at Google, that's not going to fall in. You're not using that information to report illegal activity. So we have the first case under this law, first reported case in the District of Massachusetts earlier this year, or well, at the end of last year. And I'll just read for you what is the critical paragraph, and I think this is a real misconstruction of what we just described. Loftus is the name of the whistleblower. It says, the judge says, while Loftus contends that he's entitled to immunity because he handed the documents to his attorney to pursue legal action for alleged unlawful activities, the record lacks facts to support or reject his affirmative defense. The statute doesn't talk about affirmative defense. It says immunity. There's been no discovery to determine the significance of the documents taken. Well, now we're back into the murky balancing test that we're trying to get rid of. And Loftus has not filed any potential lawsuit. Well, a False Claims Act lawsuit is filed under seal, and it's usually not filed until after an attorney has had a chance to evaluate the documents. Further, it's not ascertainable from the complaint whether Loftus turned over all of Unum's documents to his attorney. The statute doesn't say that it's a quantity measure. It's based on whether you keep it private. Taking all facts in the complaint as true and making all reasonable inferences in favor of Unum, the court finds the complaint states a plausible claim for trade secret misappropriation, which essentially puts the whistleblower in the position of having to defend what is a very costly lawsuit. Now, when I read this, I think, we perhaps could have been clearer, but it says immunity. It doesn't say affirmative defense. And I do think that there's going to be a concern that anyone's going to say, I get under this. But when the company has no evidence to suggest that it's being used for an improper purpose, I think that's what that's what the law was intended to do. But this was the first time a judge saw it, and we'll see, might get appealed. I've had some contact with the lawyer for the whistleblower, and they're sort of in a very difficult situation right now. I mean, they think the judge got it wrong, but there's a lot of power that the court wields. Now, the other thing the court says at the end of the opinion, it says, no whistleblower suit has been filed. Unum does not know what Loftus took or what he's going to do with it. Loftus's self-help discovery and threat of potential action in the future are not mitigated by the existence of an actual lawsuit. Now, first of all, almost all whistleblower cases begin in exactly this way. So the idea that he hasn't filed yet, of course, he's getting ready to file. And if you can block him before he gets to the courthouse, you've killed the whistleblower. The False Claims Act authorizes a relator to submit material evidence and information to the government under seal and to file a complaint under seal. The purpose of, happy birthday, Timothy Spearman. The purpose of the seal is to protect the government's investigation. And so I just think that the judge in this case, was being perhaps overly cautious. I think maybe the trade secret bar is happy with that caution, but I don't think that's a faithful interpretation of the statute. So that's what I had to say. I'll take questions later. I don't know if this is working.
Let's find out. Yep. It works if I look at it.
20. This is where it's
Okay.
inside.
How do I want to reset? Okay, so thank you, Dennis, and the editors of the Missouri Business Entrepreneurs and Tax Law Review. Oh, that's a mouthful. They've organized a great symposium, and I appreciate the invitation to speak to all of you. So I'm here to talk to you about a provision under the Federal Defend Trade Secrets Act that allows for ex parte seizures of goods which are allegedly produced via misappropriated trade secrets, as well as seizure of items that may contain the secrets themselves, such as computers and other documents, and how this is following a trend by which rights owners have steadily sought to shift enforcement of private intellectual property rights from themselves to taxpayers and other entities. So I'm looking at this much more like from about 30,000 feet, maybe 10,000 feet up, as opposed to the other folks here who have dug a little more deeper down into the law itself. You saw this slide a second ago. This is going green. We've all seen these. You're supposed to go green. You're supposed to get your bank statement and your credit card and your W-2 online, and this is all going to happen to save the planet. But if you're like me, if I can't balance my checkbook using using the computer screen, I print it out myself anyway. So if I chose to go green, what's really happening is cost shifting. I'm paying for the printing and the ink as opposed to the bank paying for these things. So institution has now passed on the cost of all these things, the printing, the mailing, and it's absorbed by somebody else, and we're not really going green, it's just somebody else is doing the printing. Well, this cost shifting has also been a theme with intellectual property law enforcement. The ex parte procedure provision is really just the latest of these, and it's not a right that's granted by any of the other trade secret statutes. And it's relieving the rights owners of two burdens. First, it's really relieving them the burden of having to compete in the marketplace. And the second burden they're relieved of is the costs associated with the discovery process of a lawsuit. So before discussing this new enforcement tool with regard to the DTSA, I'm going to first illustrate this enforcement shift, this evolution of this enforcement that's already present in copyright and trademark law and how it's continuing to grow. This shift of enforcement responsibilities is really just an idea that is constantly in search of new targets, trade secret law being the latest of this new mechanism. So for trademark owners have already been very successful in persuading Congress to legislate enforcement duties to governmental bodies and other entities with regard to private intellectual property rights. Customs has long had the authority to seize counterfeit goods at the border. At ports of entry, customs enforcement seizes lots of things, toys and computers and DVDs and handbags and shoes and apparels and consumer electronics. And the reliance on customs enforcement to seize counterfeit goods, you can imagine, is a huge benefit to the rights owners. And to give you an example, you can think we're probably all familiar with the Lee versus Tam case before the Supreme Court right now, where there is a ban that they're looking to see whether the ban on registering offensive marks is constitutional or violative of the First Amendment. So what happens if the Supreme Court upholds the Trademark Office's ability to refuse to register what it deems offensive marks? Now we'll assume this lack of registrability doesn't render the mark completely unenforceable, that it can still be enforced as an unregistered mark under Section 43A. So why would Dan Snyder and the NFL really care about registration if they can continue to enforce their marks? Well, because if you want government entities to stop counterfeit goods at the border that are infringing on your mark before they enter the marketplace, you must present customs enforcement with a valid registration certificate. Section 42 of the Lanham Act and Section 526 of the Tariff Act of 1930, what they prohibit is the importation of merchandise bearing a registered trademark without the mark owner's consent. No registration means no customs enforcement, and Dan Snyder and the NFL could still sue the infringers and ask for forfeiture of the infringing goods. via Section 43 of the Lanham Act, but now it's at their expense instead of ours. So basically what this does, this is a huge impact on their bottom line. Now the taxpayers are enforcing their marks through customs enforcement versus them spending the money themselves on infringement lawsuits. So this has been expanded. Enforcement against bulk importers of counterfeit and pirated goods are safely in the hands of customs enforcement, but now they had another avenue they needed to address, because you can imagine the internet marketplace allows for small-scale importation that slips under customs net. You can download things, you can purchase things that are mailed to you, much easier to get them past customs this way. So the mark owners were looking for a new way to prevent this type of importation, and they decided that the way to do this was through domain name seizure, through civil forfeiture proceedings, and this was part of the new Pro-IP Act of 2008. It stands for the Prioritizing Resources and Organization for Intellectual Property Act. Yeah, that's why they call it the Pro-IP Act. So, and it changed forfeiture laws dramatically. So it created this section 2323 of Title 18, and what it said is that any article that for the making or trafficking of which is prohibited, that included criminal copyright infringement, trafficking of counterfeit goods, and labels that falsely identifying goods as genuine, etc., were now subject to forfeiture. This was interpreted as including websites. So any property used for these purposes, used for all of these infringing activities or to facilitate them, this trafficking could be subject to civil forfeiture. But what this also did was it increased the probability that the seizure would happen to sites that were hosting non-infringing works and goods. This led to abuse in some of the seizure of non-infringing websites, and it harmed those businesses, one of which, for example, was a business called Rojo Directa. And they were targeted under what was called Operation In Our Sites, which was an ICE program in 2008 under this new Pro-IP Act enforcement right, and they would remove allegedly infringing websites. They would seize the US domain names, the US registered domain names that they believed were associated with piracy and counterfeiting. Rojo Directa's site was seized, part of what was known as an annual Super Bowl seizure spree in 2011. And the domain names they would go after sites that were allegedly infringing on NFL marks or illegally streaming games. And ICE was able to obtain a civil forfeiture order against Rojo Directa, relying on information from the Recording Industry Association. And Rojo Directa was one of two companies that fought this. And they kept saying, where's your evidence? The judge kept asking ICE for evidence, asking them for the evidence, and they were being stonewalled. They kept saying, well, the RIAA is going to get it for us. RIAA, we're waiting on them. RIAA never turned over any evidence, mostly because there wasn't any. So after 18 months, having no evidence, federal government dropped its claim to the website, and Rojo Directa got its website back. There were only two websites that actually had the resources to fight this civil forfeiture. The other one was called Dayjazz One, which was a popular hip hop blog, and Rojo Directa, they were just linking service. They linked to other websites. The hip hop website, basically anytime they were sent a takedown notice, they took it down. Wasn't good enough. They received these forfeiture orders anyway. So the others just didn't have the resources to challenge this seizure, and there's no way of knowing how many of them were not infringing, but merely lacked the resources to mount the legal fight. It was very expensive and time-consuming for the two that did, and it harmed their business. They were shut down for over a year. But so you can imagine, even though they lost their proxy-fought court battle, the RIAA and the Motion Picture Association were also winners. They shut down legitimate competition. It was a win for them. So, and the costs were all borne by the US government and the defendant website owners. So, not completely satisfied with going after Trademark, and a bit of copyright, then they decided to go after get stronger enforcement by others of their copyright. So these copyright owners have lobbied Congress, sometimes successfully, to pass legislation that would expand the seizure of domestic websites and also and in other ways shift the enforcement of rights. And they've had some failures. The Combating Online Infringement and Counterfeits Act, big mouthful, that would have allowed websites' domain to be seized if it had no demonstrably commercial significant purpose other than offering or providing access to unauthorized copies of copyrighted works. A failure. Many of its provisions were resurrected in the also failed PIPA and SOPA bills. And the Pro-IP Act actually contained a huge gift that was removed, a huge gift for the copyright owners, whereby the Department of Justice could actually file the civil actions on behalf of the copyright owners. The Justice Department could bring the civil suit in patent and against patent and copyright infringers, and guess who would get any damages? Not us. Damages would be turned over to the copyright owners. So lots of folks were against this, including the DOJ, who didn't want to become pro bono attorneys for private copyright owners. But there have been some successes. Universities are now responsible for policing their students' copyright use. Recording industry and the motion picture industry were successful in lobbying for legislation attached to the Higher Education Opportunity Act amendments in 2008. Colleges and universities now have general requirements imposed on them regarding unauthorized file sharing, including the dissemination of an annual disclosure, which we've probably all seen, especially those amongst you who are students, and they have to have a plan that will successfully combat the unauthorized distribution of copyrighted materials on their network. So they develop a plan, they want to comply, they want to make sure they still get their federal funding. So they enact policies where students can actually face academic sanctions. They can be suspended, they can lose right to their internet service, all to basically enforce the right of somebody else. So they receive federal funds, they police students' internet use and have become copyright enforcers, shifting the cost to your tuition dollars. ICANN has also now, they're trying to rope them into becoming copyright enforcers. In 1998, under contract with the Department of Commerce, the Internet Corporation for Assigned Names and Numbers, affectionately called ICANN, was formed. It's a private sector nonprofit corporation, and it manages the governance and administration of our address system, of our domain name system. And it really wasn't created or intended to be an IP enforcer, but from its very inception, it was drawn into trademark rights in domain names because Congress amended the Lanham Act in 1999 to include its anti-cyber-squatting provision, federal cause of action for bad faith registration of a domain name. So ICANN, they then, in response to this, set up an adjudication system to figure out when there was a dispute between domain names, who should get it, these words and phrases. So right now, they've become a de facto enforcement agent for trademark. But copyright enforcement was never part of their sphere of operations. They were interested in having the names created, but they're right. They never were supposed to extend this enforcement to the copyrights and other the actual content of these websites. It was never the responsibility to figure out what was on the websites. Just, well, was the name okay? Was the name okay? That was where they thought their line was drawn. But in recent years, now ICANN has faced increasing pressure from corporate copyright owners, big surprise, who really think that online intermediaries should be responsible for enforcing these rights. ICANN is trying to resist direct involvement in these enforcement activities, but it actually now has changed its contracts to support notice-driven sanctions, and canceling domain names for these supposedly pirate sites. And it's abetting the development of this at the lower, further down the line where domain names are also given out. So they're facilitating the trusted notifier program. They're once again, shifting the burden and cost of enforcement rights away from the owner. So this shift now is being seen in the provision of ex parte seizures of the DTSA. Now, 48 states, like we heard, for the most part, have adopted the Uniform Trade Secret Act, and they've pretty much been a pretty good adequate means for redress. None of them, though, have a trade secret specific ex parte seizure process similar to this provision in the federal law. State trade secret laws so far have been perfectly up to the task. They've captured large monetary awards. They've been able to seize goods and misappropriated trade secrets. Epic Systems won a $940 million suit last year. USA Power in 2012 managed to win $134 million. Paysetters won $947 million. So getting money from the states doesn't seem to be a problem. State juries are pretty good at giving away lots of money when there's a misappropriation of a trade secret. As you can imagine, this costs a lot of time and money and attorney's fees and discovery for the plaintiff. They have to request the relevant material. They have to respond to inquiries and objections. They have to store the materials. They have to review them. So this, and during all this time, the defendant's business can still continue to innovate and compete without being deprived of its resources. That changes under the seizure provision. So despite adequate remedies at the state level, there was this push for this federal action, and the biggest change that is not in state law is this seizure provision. And as I mentioned earlier, the major difference between these two sets of laws, and it relieves the plaintiff of two burdens, having to compete in the marketplace and the costs associated with the discovery process. So under the DTSA, if I'm a company, I believe the trade secrets have been stolen, I can go to court, I can say, I need you to seize all this stuff. Don't have to provide notice. Without providing notice, I can ask for a court order to seize the trade secrets, even the computers on which they reside. I can take everything. And federal marshals show up at your business and seize your computers and your cell phones and your flash drives and your documents. So they're all seized by the U.S. Marshals. Then they go to a special master who's appointed by the court, who then reviews all these documents, identifying what materials are misappropriated content, preserve that, remove it from the computers if necessary. Court hires technical experts if necessary to assist. So all this time and labor and skill is at the expense of the courts and not the plaintiff. Supposedly, the plaintiff's business is prohibited from directly accessing these seized materials, but in the meantime, the court has appropriated the tools necessary for the defendant business to function. You've taken all of your resources. This defendant has lost their computers, they've lost their phones. They can't function as a business. It's massively disrupting that targeted business. It could temporarily shut it down. It could even kill it. So the plaintiff company has effectively eliminated the competition without litigation. There's no need to even compete in the marketplace via producing better products or other silly things like that. And instead, they could use the government to shut down competition. So it's created this extreme remedy where a trade secret plaintiff can pretty much claim almost any basis to argue that, oh gosh, things have to happen quickly without notice to preserve our trade secret from misappropriation, leading to anti-competitive abuse. Startup companies are going to be very vulnerable when they're faced with the sudden seizure of their computers and documents and other items which will contain unrelated material and have no recourse until these things are released either at another hearing or at the end of adjudication. So again, we see a shift to the taxpayers. The plaintiff has given a $2,000 bond for and the seizure. They say, well, it's necessary for the preservation of evidence, and it's all performed by officers of the court. It's basically an unprecedented remedy that can be used to effectively shut down legitimate competition. So imagine if you're a recent case involving Surenda Mishna, who is accused of misappropriating trade secrets from his employer, Magnesita Refractories. Excuse me, your laptop is seized, you no longer have access to anything on it because your employer thinks you're conspiring to misappropriate trade secrets. The court, though, obviously has not read the DTSA carefully, and instead of having it go to a special marshal, a special master to look it over, just says, oh, don't worry, we're just going to give it to Magnesita for 48 hours so they can make an entire imaging of everything on your computer and return it to you. Not supposed to be doing that. So they're not even paying attention to what the law says. So now what's happening now is Magnesita has possession of Mistra's own independently created confidential material. They have now just taken their competition's computer, have complete access to everything Mishna had thought of on his own, and so they have now legally misappropriated Mishna's trade secrets. A preservation order would have served the safe purpose, and it's already available under existing law and court procedures. So as for shifting the cost through the discovery of a lawsuit, trade secret owner now can use the government seizure and review of the materials as a substitute for the discovery process that would normally, a lot of it would be at the plaintiff's expense. Identifying relative evidence for collection, preservation, and destruction is all transformed into this all-encompassing sweep up by U.S. Marshals of documents and computers and anything else that may contain the allegedly stolen secret. The court stores these materials. The appointed special master reviews these materials for relevancy. They're looking it over, they're isolating. Everything is then passed the presiding judge. So it's a boon to the bottom line of trade secrets owners with little risk other than this $2,000 bond. So you see, I hope I've been able to, to demonstrate how this is really a part of this overall shift in the costs associated with enforcement of IP, and this is merely a new avenue, and is a great way to stifle competition in an anti-competitive way. And it has a strong potential to become an anti-competitive arrow in the IP owner's quivers through this cost-shifting and hindering competition that is completely unrelated to one's reputation. And really only time, it's a new enough law, it's only time will tell, if this is abused, how much it is abused, and how it will play out overall. So, thank you.
Right. Thank you. So we're going to do a Skype call, and as Daryl's setting that up, I might take the prerogative and ask a question. Peter, can I ask you a question? Sure. One of your examples, several of your examples were about people going public as whistleblowers. But then when we drill in on the Trade Secret Act, it's specifically focused on whistleblowing to the government, and I am, and in my mind there are it can be equally powerful to disclose publicly, right? To go public with something, and especially when a company is doing something that might not be illegal, but that the public would really disagree with. And so my question for you is, you wrote this provision, essentially. Should it be broader, or are you okay with its narrowed focus here?
I mean, I'm someone who believes in the intellectual property system, and I also believe in the need for respect for law, for fidelity to all these other laws that companies, trade secret owners are interacting with. And so when a trade secret system that was designed for commercial purposes to enable companies to protect innovations and ways in which they can perform better as a business get used to try to silence people who would be reporting on illegal activity. That's a very delicate balance to try to draw. And so, in fact, the way in which this is drafted, which is the way, was the concept that I tried to bring to it, is to actually channel whistleblowers to these trusted intermediaries, the government and to lawyers, to ensure that we have some mediation of that process. In fact, I think that the law is something that companies should be supportive of, in that this will enable there to be some breathing space for this information to be processed. Yvette was talking about concerns about shifting costs. There are going to be costs associated with everything that we do. And one of the questions I would ask for her, because I don't know that these seizure provisions are the worst solution. I think we ought to be trying to come up with who's the least cost avoider, what's the best way to share these costs. And I would worry if people were taking information to the New York Times, because the information might in fact disclose commercial. But I think there are pretty clear cases that once the government sees what's going on, they're going to take action. The companies will then be involved in another legal proceeding trying to correct whatever a company has done that we want to have corrected. So I think the notice disclosure provision, the notice provision, is actually a benefit to companies, because it's saying to your employees, listen, if you have a problem, you can report it internally, you can report it confidentially, but don't publicize it. Don't put it on a website. That's not the way to go. Now, when you talk about someone like Edward Snowden, I don't think he fits this model at all. I mean, he was dealing with untrusted intermediaries. I think, and whether you agree or disagree, I think there's no doubt that he faced a very difficult dilemma. He knew that if he reported it upstairs at the NSA, that they were going to crush him like an ant. And so that's not really what I'm focused on. I'm focused on situations where you have someone at a healthcare provider or defense contractor, and they know that these are defective munitions, that they know that this is a Ponzi scheme. And they're essentially going to go through a very careful, deliberate process. And I think that all lawyers who are working in the trade secret area, they should really read up on how whistleblower actions work, because when you know that there is a good process that's going to protect the trade secrets, that's going to ensure that there is an orderly process, that's in the best interest. We ought to, in some ways, just kind of slow down the process and make sure we're being careful. So I'm on board with the way this is drafted. I'm a little nervous when I hear that companies don't think that they should provide the notice, because it's true that there are tepid remedies. If you don't provide notice, it just means you don't get exemplary damages. And perhaps we need to have a stronger incentive. I think we really want to mandate that employees know their rights and that the public is protected against illegal activities in companies.
Are we good, Derek? Okay. All right, thanks, Peter. Hey, Robin.
Can you all hear me and see me?
Yes.
Excellent. All right, so I'll just go ahead and begin. I was following the live stream until about 2 minutes ago. So thank you so much for having me, especially via Skype. It's very helpful. So I will talk today from a little bit of a different angle. You've heard a lot about some substantive aspects of trade secret law and the DTSA, and I'm going to be talking more about the procedural aspects, which I think are crucial. So to give you all some background of how I got into this, when I was a law student, it was right after Congress had passed the EEA, the Economic Espionage Act of 1996. And for those of you who aren't familiar, that was the statute that formed the basis of the DTSA. So it was a statute that provides criminal enforcement of trade secret misappropriation. And I was interested in this when I was in law school because it seemed to provide enforcement that went well over some of the floors for what is required of trade secret protection in TRIPS, which is the international treaty that's part of the WTO for for intellectual property. So at that time, what I was interested in was the idea that the US was going to use these procedural mechanisms, which is namely extraterritoriality, to sort of impose a higher level of trade secret protection on some countries via extraterritorial enforcement that we couldn't otherwise get through negotiation or bilateral or multilateral agreement. So fast forward about 20 years, we get the DTSA. And what I found fascinating was that the DTSA has almost a mirror image problem of the EEA, which is instead of using these procedural mechanisms to kind of impose higher enforcement on the rest of the world, we encounter our own procedural stumbling blocks in trying to domestically enforce conduct that perhaps happened here, perhaps happened overseas, but trying to target overseas actors. So what I'll talk about today are what I see are the two big barriers to enforcement of the DTSA. And I just want to sort of bracket this by saying nothing that I'm saying here should be taken as kind of an endorsement of the DTSA on its substantive terms. So I think there are several problems with this statute, with the so-called need for uniformity in federal law of trade secrets. But this is sort of taking the statute on its own terms, which is if this statute is doing what it purports to do, which is to cast a wider net, particularly over foreign actors who are misappropriating trade secrets, do we have the procedural mechanisms to actually enforce this law? So I'll start with personal jurisdiction. So if you want to kind of think back to your first year of law school, if it isn't too traumatic for you to remember personal jurisdiction, I will give you kind of a quick overview, which is that no court in the United States, whether it's federal or state, can exercise jurisdiction over a defendant unless it ports with due process, right? And under international shoe, that means we're looking for minimum contacts with US. Now, trade secrets present a particular problem for personal jurisdiction when we're talking about foreign actors, because the situations in which the Supreme Court has had the most trouble in articulating standards for what constitutes a minimum contact are when we're dealing with foreign defendants and also when we're dealing with intangible harms. And of course, intellectual property and trade secrets are classic cases of intangible harms, right? So we're not talking about a water heater that is sold in Illinois and explodes and physically hurts someone. We're talking about these intangible harms that can be very difficult to define, not only what the harm is, but where the harm is occurring. So recently, the Supreme Court has had almost an allergy to talking about personal jurisdiction and anything to do with technology and the internet. In fact, there was a case that came before the Supreme Court called J. McIntyre versus Nicastro a couple of years ago that had nothing to do with the internet. And they couldn't find a majority opinion there because Justice Breyer basically said, this case isn't about the internet, so I'm afraid to say anything. Right? So we have sort of continuing lack of clarity from the Supreme Court when it comes to what constitutes a minimum contact. So what does that mean? It means that for things like trade secrets, we're left to guess, well, how do we know when there are minimum contacts with the United States? And the first problem where there's kind of a gap between the DTSA as it's conceived and how it might be enforced is that the Supreme Court has been very stubborn about allowing courts to think of the United States as a single sovereign or a single market when it comes to personal jurisdiction. So if you want to exercise personal jurisdiction over a particular defendant, it's not enough that they have minimum contacts with the US as a whole, right? So if they have, a little bit of contact with Wisconsin, a little bit of contact with Massachusetts, right? Harm that's occurring kind of diffusely over the US market, that has been explicitly rejected by the Supreme Court. You have to have contact with a particular state. Well, as we've heard right from the other panelists, and also just in thinking about IP and trade secrets, these are classic examples where you are dealing with the U.S. as a unified market. Nobody thinks of protecting their trade secret in Virginia, but not protecting their trade secret in Wisconsin, right? That doesn't make any sense. And yet, that's kind of what the Supreme Court would demand. Now, interestingly, the drafters of the statute could have done something about this, right? So Congress is actually empowered to authorize what's called nationwide jurisdiction. And they could have put something about that in the statute, just like they could have made the DTSA preempt state law, right, if they were so concerned about uniformity, but they didn't, right? So this exists alongside these various state law remedies. So it leads us to wonder, how do they expect to get minimum contacts over many of these foreign defendants, right? And so I'll say just a little bit more detail about why this is problematic. Let's say that somebody is obtaining trade secrets by hacking into computers in the US, right? Particularly if the information that they're obtaining is stored on a server that is located in one state, or located not even in the US at all, right? It could be on one of these crazy server ships that's floating around in the middle of the ocean. It could be a server that is on a Caribbean island, right? It might not be territorially in the US, yet that's their contact with the particular plaintiff, right? Is hacking into that server or hacking into that computer. Well, the next thing you'd have to ask yourself is, did they mean to target the plaintiff where the plaintiff was? But again, if the plaintiff is a major US corporation, it's hard to say where the plaintiff is, right? Is the plaintiff at its corporate headquarters? Is the plaintiff at the state where it's incorporated? Is the plaintiff at a state where it has large research and development facilities? Is the plaintiff located in a state where it makes a lot of sales? Right? If it's hard for us to answer that question, then it becomes even harder to say, oh, well, the defendant was explicitly aiming and targeting the plaintiff where they were. Right? So it can be very hard in these cases to say, we have minimum contacts. And that example that I just gave, again, shows why the territoriality is so difficult, right? If you were dealing with the US as a single market, you might be able to add up all of these different things and say, well, the plaintiff was targeting this company generally in the US, but that's been foreclosed to us by the Supreme Court. So that's the main problem with personal jurisdiction, right? Is that with a lot of foreign defendants, if they never set foot in the US, right? If all of their trade secret misappropriation is occurring kind of in the ether, right? Or through hacking or abroad, it's going to be hard to connect them to any one jurisdiction. But there can be cases, right, I think, in which, particularly if you're dealing with a foreign company and not a foreign individual, that you might be able to establish personal jurisdiction, right? They have just enough contacts to meet minimum contacts. Well, now we have a second problem, and that's something called the doctrine of forum nonconvenience, which sometimes is covered in civil procedure courses, sometimes not. So forum nonconvenience is a common law doctrine that allows federal courts to dismiss a case entirely, even if they have jurisdiction over the case, if they believe that this particular jurisdiction is not a good or a convenient forum. And this doctrine is used primarily to dismiss cases that courts think should really be litigated in a foreign forum. And so the things that courts will look at are private factors and public factors. So they'll start off by deferring to a plaintiff's choice of forum, and this deference is especially high when the plaintiff is domestic, so that can help here, right? But that's the meaning, right? The deference to the plaintiff's choice of forum over the last 20 years of forum nonconvenience doctrine has become smaller and smaller. So courts have been focused less and less on saying, okay, plaintiff, you say you wanted to sue in New York, go ahead and sue in New York federal court, and focusing more on third parties and defendants. So one of the things that courts will look at are private factors. So where are the witnesses and the sources of proof? Well, in a lot of trade secret misappropriation cases, the witnesses and the sources of proof about whether the trade secret misappropriation happened and how and why will not be located in the chosen jurisdiction and probably not located in the US at all. Right? They're going to be located abroad, they're going to be located possibly in the cloud and physical manifestations of the cloud. And so these are cases in which the court is going to see less of a connection to the jurisdiction. So the best a plaintiff could do is to sort of say, well, we have a lot of witnesses and sources of proof that go to things like the harm that we suffered here, but that's not as convincing to courts, right? When they're talking about the location of witnesses and sources of proofs, they're really thinking about the witnesses that go into the question of liability and not necessarily the question of remedies. So then there are public factors, and public factors basically ask whether this controversy is a local controversy. And if the controversy is seen to mainly involve foreign actors and foreign activity, even if it involves a domestic plaintiff, they're going to say, what interest does our forum have? And this is where forum nonconvenience might interact with the problems of personal jurisdiction. So it might be that because of the craziness of the minimum contacts doctrine, the only US jurisdiction where a plaintiff can say that the defendant had minimum contacts is also a jurisdiction in which the plaintiff doesn't necessarily have a lot of connection. Right? So now the controversy, even though you've managed to sort of squeak by on personal jurisdiction, the controversy isn't particularly local. And so this gives the court even more reason to say, okay, we're going to dismiss this on forum nonconvenience grounds. So those are the two big stumbling blocks. And the next thing that I want to talk about is what I think of as sort of the irony of the situation, or maybe irony is the wrong word. It's probably in the Alanis Morissette sense, right? Not that sense of the word. Is to think about who designed these doctrines. So personal jurisdiction has gotten incredibly narrow over the last 20 years, and forum nonconvenience has gotten incredibly strong. And who were the big movers and shakers behind this? Well, if you look, they are the same people who begged Congress to pass the DTSA. So the Chamber of Commerce and large multinational corporations with big US presences who were concerned about trade secret misappropriation. These are exactly the same people who have been writing amicus briefs about personal jurisdiction and forum nonconvenience, asking for a more restrictive approach. And so one of the things that strikes me as interesting, especially now that we are post-election, is that in a way, the DTSA and how it was crafted procedurally kind of presaged this sort of Trumpism approach to trade protectionism and procedure, which is not really thinking through the full relationship between needing things from a global economy, but also closing off the US from other global influences, right? And so trade misappropriation is kind of this wonderful example where we are worried on one hand about these sort of shadowy foreigners who are clawing at our gates and trying to pilfer our information, and we're not sure who they are, but we need a remedy, and we need to sort of put up a wall, right, whether it's legal or procedural or even physical, to make sure they don't come in. And yet at the same time, it's this very global, outward-looking statute, right? It's built on a statute that was trying to kind of impose US trade secret protection law beyond our borders on the rest of the world, right? And say, no, you actually need stronger protection against trade secret misappropriation than TRIPS says it does. And so the neat thing about personal jurisdiction and forum nonconvenience is that they expose how it's really hard to have it both ways, right? It's hard for US corporations and big multinational corporations to say, we want really strict personal jurisdiction laws because we want to minimize our exposure to liability in a US forum. But at the same time, we would like there to be really strong laws that allow us to go after defendants in foreign jurisdictions, right? And that's kind of the neat, what we call in procedure, transsubstantivity of procedure, which is that you can't pick and choose your procedures and have them apply to one area of law and another area of law. So what's good for product liability also has to be good for trade secret misappropriation, or else you find yourself in a box. So those are kind of my thoughts on how this interacts with procedure. And I look forward to any questions you have for me and hearing what people have to say about these posts as well. So thank you.
You have to come back out, Professor Liebesman. Hey, thank you very much. So we have time for questions, and you all may have responses as well. And I'm probably going to moderate these just because you don't have microphones on, so that I'll repeat the question so that Robin can hear it as well.
Actually, I have a question for Professor Menell. The purposeful misreading of your immunity by the judge that you're worried about, or do you think it's some of the motivation of it is the fact that judges and other people don't like to see individuals make a windfall for being a whistleblower, regardless of the fact that you're trying to, there's good reasons for the claims to have people bring them forward. But the 10 to 30% against the pharmaceutical company, the judge isn't gonna necessarily, in public opinion, doesn't follow that. Except one person should get a windfall.
Dennis, you want to repeat that, or you
want well, right, Robin. The question, but it's primarily for Peter, is, as I take it, could we expect maybe courts to intentionally misread the immunity defense and maybe other areas of whistleblower law as well to limit windfall profits that they get from this? And that's...
So let me just say, I don't think the judge purposely misread it. I don't want to read anything into... He was the first judge to get this. He received argument from, from two lawyers. I spoke with one of them afterwards, and he said at the hearing, no one could really tell where the judge was leaning. And then he did issue this opinion. The case is ongoing. No appellate court has seen this issue yet. So my hope is that we will get a faithful interpretation of the statute. But I do acknowledge that the statute uses a term, immunity, that's open to some interpretation. I just don't think the judge appreciated what was really going on. Now, your broader point, which is, are judges skeptical of the whistleblower statutes? And it is true that they can produce a large return, but I'll also say that most whistleblower cases don't go well for whistleblowers. And on average, I don't think that the returns are really that high compared to other sort of civic acts. I mean, I think that we benefit as a society from whistleblowers, and had someone come forward in the Madoff case, we could have paid him $5 billion, and it still would have been a great return on investment for the public. And no one would get $5 billion in a whistleblower case like that. If anything, the SEC, amounts are in the millions, and it's still, quite an act of courage in today's, environment. I think it's very hard for whistleblowers to come forward, even with these rewards, and many of them don't even know about the rewards, so it's a complicated dynamic. I think what the trade secret provision is doing, the defend trade secret provision is doing, is it's really bringing in some broader social concerns into trade secret law in a productive way. I think it's a real problem in our society that trade secrets are being used for purposes other than commercial advantage. That's what trade secrets should be about. And if you're using it to cover up that you're defrauding the government, defrauding shareholders, violating statutes, then you should be no more protected than for any other citizen reporting. But because you have a non-disclosure agreement, up until now, companies had this threat. Even though the comment in the Uniform Trade Secret Act acknowledged that there could be an exception, it was very, very hard to apply that exception. So now we have a clear rule, and I'm hoping courts will do it, and I hope corporations will just say, listen, we should not be in the business of succeeding based on non-commercial and illegal activities.
Professor Liebesman, I was one thought that struck me from reading your work and hearing your talk is the idea. I wonder whether you pointed to some analogies of this expansion, but it seems like you left off a very long history of this. For instance, if someone steals my car, the law enforcement goes after them, prosecutes them, will help me recover my car. Likewise, likewise in other areas of personal and real property, we have a long tradition of having government step in on our behalf, cover certain legal costs, recover some amount of recovery costs, bringing the sheriff, et cetera. Can't we just see this as a natural extension of that?
Well, okay, so let's take your car example. Let's say I steal your car and I go joyriding in it and I totally total it. The government, there's two causes of action here. The government has a right to secure its citizens and punish me for destroying your car. But the government doesn't go after me to replace your car. That's still up to you to file a civil tort claim against me for me to give you the money to replace your car. So what this is doing is it's kind of taking you having to sue me for the money for your car, which the government currently doesn't do. You just get the car back in whatever conditions it's in, and if it's destroyed, you're out of luck. You're not getting money from. Maybe you'll get money from some victim defense fund or whatever, but whether it covers your car or not is irrelevant. You still have to sue me to get the money for your car, to replace your car. The criminal cause of action does nothing to make you whole in terms of your car. It just punishes me.
So these IP actions are almost like leapfrogging beyond this whole tradition.
Yes. So what I'm saying is that it's not about punishing me like the Espionage Act would punish me and puts me in jail. But it doesn't do anything about seeking any remedy for trade secret. And that's what's going on. So we're seeing this creep of basically outsourcing enforcement, that civil enforcement and those civil remedies onto somebody else.
Yes.
And Orly has a question.
Professor Liebesman,
yes.
You mentioned startups basically being kind of halted because of these ex parte seizures. What, if anything, can companies do to kind of preemptively protect themselves from these ex parte seizures? Is there anything they can do?
You mean like a startup? So in terms of if they can seize everything, they can. I mean, there's technology out there. I have no idea because it's first of all it's supposed to be taken. Maybe drop boxes. Maybe they're. I've been doing a lot of thinking about that myself. It's like what things can you do to protect yourselves? And I think that's a matter of looking at technological things. It's looking at things like having your stuff, your things that have nothing to, coordinating off anything, having duplicates. Nothing backs up like paper, things like that, you know, having them stored elsewhere. But even then, if they have an order that says they can seize everything and then go through it, there is very little you can do if they sweep up everything you own. I've been racking my brains to try to come up with all sorts of, well, what if they did this and what if they did that? And the bottom line is that a broad enough order, they can say, well, it's as narrow as it needs to be because they could be putting that trade secret stuff anywhere and we need to stop them. And, you know, unless you're like, you know, have like a gazillion flash drives everywhere with everything you have in on, hit them, you know, in all sorts of weird places in your house and in your, you know, wherever, you know, basically it's, you know, putting the stuff someplace where it can't be found. But even then, now they may, you know, who's to say you didn't also put the trade secrets there too? So.
Professor Yvette?
Yeah, so sort of a comment, more of a comment. I had the same thought with Dennis about how cost shifting in trade secrecy has also been very much cost shifting with criminalization.
Mm-hmm.
So the
Yes.
FBI, I wrote this article about how much these sort of common resources are now put in by government. And there is this hypothesis that it actually will reduce the kind of precautions that that companies are putting into their own protections, and especially since it's in parallel, and it's not exactly analogous to the car retrieval, because on both the criminal side and the civil side, you get an injunction, and that's actually what you want to restore your exclusivity. At the same time, it seems like, and it links to the whistleblowing question, part of the resistance of relying solely on government, and this is why the seizure is so powerful, is I brought this FBI agent to speak to my class about the kind of education that they do to companies, and one of the big issues that they've encountered is that the companies don't want to tell them about any potential leaks because they are afraid. You know, once the material, once the information is in the hands of government, they fear that. So I was wondering if either you saw that as part of the resistance to any kind of whistleblowing, you know, that government won't be, any arm of government won't be safe in keeping that information. And they keep telling us, you know, when they go around the country, we have all these processes and we'll keep it secret. But the kind of other side of it is the self-help, and very strong self-help that the seizure process gives.
Do you want to comment first?
I can go. She ended you all.
So there just isn't a lot of evidence that the government is untrustworthy.
No, I agree with that.
And so, you know, on the issue of protecting trade secrets, I'll focus on that issue because that's the one before us. And I do think that, you know, we have had, you know, good onboarding of federal government employees. They seem to understand this, and we're able to operate in a lot of agencies, you know, with these sort of secrecy systems in place. And I just, you know, I think we're looking for creative solutions to difficult problems. And I guess what I would say is that I'm not as offended by the concern that trade secret owners have with regards to some of the cybersecurity problems that have occurred. And I don't think the fact that you might be able to get a monetary remedy later in a state court proceeding is the best strategy for all of these situations. There are many of these cases that are never going to be brought because you don't have jurisdiction over the defendants, that you don't have a deep enough pocket to you know, so typically when we're dealing with forfeiture issues and injunction issues, we're trying to say, is there an adequate remedy at law? You know, are we going to be able to put someone back in a position? And you know, when I hear these sort of examples, it doesn't give me enough data. So Roja Directa, to Jazz. There were hundreds of seizures, and you're suggesting that they were all equally situated. In fact, there's tremendous evidence that most of these were pirate websites. The overwhelming majority. In fact, when we look at data on the 512 safe harbor, where the recording industry and the motion picture industry, as well as individual copyright owners, are submitting hundreds of millions of takedown requests. Hundreds of millions. I was at a conference celebrating the anniversary, I forget which one, maybe the 15th anniversary of the DMCA. So it was 2013. And there were people from the recording industry there saying, yeah, we've filed, this many hundreds of millions, and there have only been like two or three out of hundreds of millions where, people have successfully come back to us. A very small number. So, we're trying to come up with regimes that can match the reality of kind of the mass digitization that's going on. And so I do think that we ought to be open. And what I would rather see is coming up with compensatory mechanisms on the back end. I mean, we should restore Dejaz and Roja Directa to their position. That would be the right thing to do. And I would like the industries that are pushing for these to actually step forward and say, we'll agree to that. We think we should. We should give, when Professor Usher at Penn State was, had his websites taken down and he experienced these things, well, it's because he was not pirating Usher music. It's because he has he has a last name that got him caught up in these kind. Now, I think Professor Usher should have had lifetime tickets to all Disney theme parks forever, and that the industry should have gone out and said, we are really terrible, we feel terrible about this, it was a mistake. But that's the world we're living in. We're in a cybersecurity world where we're going to have to make judgments, and I just think we ought to be concerned about trying to restore people when we make mistakes.
But we've seen in section 512F how weak it is that even like VIO, for example, they were completely innocent, they were sued, they were for infringement, they won, they went for attorney's fees, and they said, no, it was frivolous, but we're not frivolous enough.
Wait, which case?
The VEO, V-E-A.
VEO? No, I disagree with that. In fact, I've seen the data, and I've seen what VEO was doing, and I certainly, they had sort of, the record was not good in that case, and it wasn't careful. And so when we look at, right now, the Copyright Office is looking at the whole sort of takedown regime, and frankly, I don't, because I think the courts have misinterpreted 512, and you had evidence of Russian companies that were hired by VEO who were screening, and those people were told, they wrote back to VEO in the US and they said, hey, you're asking us to screen for you, but like whenever we see these names, aren't they infringing, and isn't this the kind of thing we ought to be removing? And then the answer is, don't respond to us by email. Call us and we'll talk about how you should proceed. Now, I think that was clearly red flag knowledge. And I don't see why the Ninth Circuit misinterpreted that.
VEO won, but they're still dead.
No, but I'm saying that it was much murkier than you're suggesting.
Yeah. But
we're going to pause, in fact, because we have lunch. And I want to, so before we thank our speakers, I just want to, so we have lunch that is not in this room, but it's downstairs in what we call our fireplace lounge, which is outside these doors, turn to the left, go down the stairs, and then over to the left, and there's a fireplace. And so there's food there. And this is intended to be a networking lunch, and so if you see somebody you don't know, then you talk to them, and that's how it works. And then we'll meet back here at 1 o'clock for our keynote address. Thank you guys very much. Thank you, Robin.